Over the last few years, Australia has seen some of the biggest changes to employment law in decades. Through the Fair Work Legislation Amendment Act 2023, also known as Closing Loopholes Act, and the Fair Work Legislation Amendment Act 2024, known as Closing Loopholes No. 2. If your business employs casual staff, engages independent contractors, uses labor hire workers, or even contacts employees after hours, these reforms may affect you. Hi, I'm Damin Murdock, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is my AI avatar presenting from a script that I've personally written and approved. The common theme behind these amendments is that the law is becoming less focused on labels and more focused on the practical reality of how people work. Today, I'll walk you through the major changes, explain what they mean for employers, and discuss the practical steps businesses should be taking to remain compliant. Let's start with what is probably the most talked about reform, the right to disconnect. Under this legislation, employees have the legal right to refuse to monitor, read, or respond to work-related contact outside their working hours, unless that refusal would be unreasonable. Whether a refusal is reasonable depends on a number of factors. The Fair Work Commission may consider urgency, the employee's role, their compensation, and personal circumstances like carrying responsibilities. For example, if you send an email to an employee at 9 p.m., they don't automatically have to read or respond to it. Whether they're expected to respond depends on factors such as how urgent the issue is, whether they're paid to be on call, their seniority, and their personal circumstances. For larger businesses, these provisions applied starting the 26th of August, 2024. For small businesses with fewer than 15 employees, they commenced on the 26th of August, 2025. This means businesses should carefully review their expectations around after-hours communication and ensure managers understand when it is appropriate to contact employees outside ordinary working hours. Another significant reform relates to casual employment. Historically, there has been litigation over whether someone was actually a permanent employee in practice. The amendments shift the focus away from looking at the wording of the employment contract and instead require consideration of the practical reality of the relationship. An employee will generally only be considered casual where there is no firm advance commitment to ongoing work and where the employee receives casual loading. The reforms also change the way casual employees move into permanent employment. Under the previous system, employers had a positive obligation to review eligible casual employees and proactively offer them conversion to permanent employment once they met the relevant criteria, unless there were reasonable grounds not to do so. That system has now been replaced by what's known as the employee choice pathway. Instead of employers initiating the process, eligible casual employees now have the right to request conversion themselves. For employees working in non-small businesses, that right generally arises after 6 months of regular employment. For employees working in small businesses, the right arises after 12 months. Once a request is made, employers must properly consider it and can only refuse on fair and reasonable operational grounds. For example, where the role is expected to cease to exist, where there will be significant changes to the employee's hours or days of work, or where there is a genuine structural change to the business that makes permanent employment impractical. For employers, this means it's no longer about remembering to make an offer at the right time. Instead, businesses need systems in place to properly assess and respond to employee requests while ensuring any refusal is supported by legitimate business reasons. Another important change is the distinction between employees and independent contractors. For many years, Australian courts placed significant emphasis on the written contract when determining whether someone was an employee or an independent contractor. If the contract was carefully drafted and reflected a genuine independent contracting arrangement, that was often the starting point for the analysis. However, the Closing Loopholes amendments shift the focus towards the practical reality of the relationship. Now, when determining whether someone is an employee or an independent contractor, decision makers are required to look beyond the label used in the contract and examine the true nature, substance, and day-to-day operation of the working relationship. In other words, simply calling someone an independent contractor or having them sign a contractor agreement doesn't necessarily make them one. For example, if a worker performs the same duties as employees, works regular hours exclusively for one business, uses the company's equipment and systems, is closely supervised, and has little genuine independence, Those factors may point towards an employment relationship, regardless of what the contract says. On the other hand, a genuine independent contractor will usually operate their own business, have greater control over how the work is performed, may work for multiple clients, and carry a greater degree of commercial risk. This change reflects a broader theme running throughout the Closing Loopholes reforms. The law is becoming less concerned with labels and more concerned with substance. For businesses, this means contractor arrangements should be reviewed regularly to ensure they accurately reflect how the relationship operates in practice. Simply relying on a well-drafted agreement may no longer be enough if the day-to-day reality looks like employment. Another important reform is the introduction of new protections for certain gig economy workers. Traditionally, many people working through digital platforms, such as rideshare drivers, food delivery drivers, and some owner drivers, fell outside Australia's workplace relations framework because they were generally classified as independent contractors rather than employees. That meant they weren't entitled to many of the workplace protections available under the Fair Work Act. The Closing Loopholes reforms change that. For the first time, the Fair Work Commission has been given the power to establish minimum standards for two classes of independent contractors: digital platform workers, such as rideshare and food delivery drivers, and road transport contractors. These minimum standards can deal with matters such as minimum rates of pay, insurance arrangements, deductions, record keeping, consultation requirements, and dispute resolution processes. Importantly, these reforms do not automatically make gig workers employees. Instead, they recognize that while many of these workers remain independent contractors, there should still be minimum protections in place for certain types of work. For businesses operating digital platforms, engaging owner drivers, or relying on these types of contracting arrangements, it's important to understand that the Fair Work Commission now has significantly broader powers to regulate how these relationships operate. Perhaps the most significant reform introduced by the Closing Loopholes legislation is the criminalisation of intentional wage theft. For many years, employers who underpaid staff primarily faced civil penalties. While those penalties could be substantial, deliberate underpayments were generally treated as regulatory breaches rather than criminal offenses. That has now changed. Under the new framework, employers who intentionally underpay wages, superannuation, or other employee entitlements may face criminal prosecution. It's important to emphasize the word intentional. The legislation is aimed at employers who knowingly or deliberately fail to pay their employees their lawful entitlements. It is not designed to criminalize genuine payroll mistakes or honest administrative errors. For businesses that discover an error, the appropriate response is to investigate it promptly, calculate any underpayments, rectify them as quickly as possible, and ensure payroll systems are updated to prevent the issue from happening again. The maximum penalties are substantial. Corporations can face up to $4.69 million, while individuals may face significant fines and imprisonment for up to 10 years. Importantly, these target intentional underpayments. If you identify genuine payroll errors, act promptly to correct them to ensure compliance. Another significant reform introduced by the Closing Loopholes legislation is what's commonly known as the same job, same pay provisions. These reforms are aimed at labor hire arrangements. Historically, some businesses engage labor hire workers to perform substantially the same work as their directly employed workforce, but paid those workers less because they weren't covered by the business's enterprise agreement. The government's concern was that in some cases, labor hire arrangements were being used to undercut negotiated wages and conditions. The new laws give the Fair Work Commission the power to issue what's called a regulated labor hire arrangement order. If such an order is made, labor hire workers performing substantially the same work as employees covered by an enterprise agreement must generally receive at least the same rate of pay as those employees. It's important to understand that these laws don't prohibit businesses from using labor hire workers. Labor hire remains a legitimate and important part of many industries. Instead, the reforms are designed to ensure that businesses cannot use labor hire arrangements simply to avoid paying the rates that would otherwise apply under an enterprise agreement. For businesses that regularly engage labor hire workers, it's important to review those arrangements carefully and consider whether the new same job, same pay provisions may apply. The amendments also strengthen the legal rights of workplace delegates and union representatives. Employers are now required to provide delegates with reasonable access to facilities, reasonable time to perform their representative functions, and paid leave for approved training. Businesses should ensure that their workplace policies and management practices reflect these expanded obligations. So, what should employers be doing now? The first step is to review your employment contracts, contractor agreements, and workplace policies to ensure they reflect the current law. You should also review your casual workforce to determine whether any employees may be eligible to request permanent employment. Businesses should assess whether contractor relationships genuinely reflect independent contracting arrangements, review payroll systems to ensure ongoing compliance with wage obligations, and consider implementing policies dealing with after-hours communication and the right to disconnect. Taking these steps now is almost always more cost-effective than responding to a Fair Work investigation or defending legal proceedings later. The Closing Loopholes reforms represent one of the most significant changes to Australian employment law in recent years. The legislation affects how businesses engage casual employees, classify contractors, communicate with staff outside working hours, manage labor hire arrangements, and comply with wage obligations. For employers, the key message is simple. Don't assume your existing contracts and workplace practices remain compliant simply because they complied with the previous law. Now is the time to review your employment framework and make any necessary changes before problems arise. At Leo Lawyers, we regularly advise businesses on employment contracts, contractor arrangements, workplace policies, and Fair Work compliance. If you'd like advice tailored to your business, you'll find our contact details in the description below, or visit us at leolawyers.com.au. Thank you for watching, and I'll see you in the next video.